be agreed to. I call the Honourable David Parker.
Thank you, Mr Speaker. The Labour Party supports this bill to Select Committee. Can I thank the Minister for the work that's been done on this bill? It's largely administrative. Before I address some particular provisions in the legislation, and can I also thank the Attorney for he's probably had a pretty significant role in relation to changes to the court rule. Can I set out what the Labour Party's view is as to the problems that we have in some of our civil court processes? We have courts so as to enable people to resolve disputes without resort to standover tactics. Essentially, courts exist to resolve disputes that parties cannot resolve between themselves. Sometimes the cause of those disputes is intransigence or unreasonableness on the part of one party, and indeed I would think that a good proportion of cases that come to trial are of that nature. Some cases it's because there is a legal uncertainty as to a principle that has to be resolved by the court system. In either case, the mechanism that we've set up in civilised countries to resolve these disputes are to have independent arbiters who are free of corruption and undue influence to determine the disputes, and then litigants have the opportunity to put their case before the arbiter, and 99 out of 100 litigants, they mightn't be happy with the outcome that they get because they all want to win, but some of them lose. But 99 out of 100 litigants are satisfied that the process is fair and they can put up with the solution that is imposed upon them by the courts, because the courts impose solutions, and then they can get on with their lives. And so we don't have ongoing rancour, and neither do we have violence or corruption as being the means to settle disputes. Now, the problem that we've got in court systems around the world and in New Zealand is that access to that form of justice, which is so admirable, is largely a function of cost. And if the cost of process becomes so high that most ordinary New Zealanders cannot afford to use the court system, then it fails to meet the social purpose which the courts are there to fulfil. It's all very well having a perfect outcome, but if that perfect outcome cannot be accessed because of the cost of the process is so high, then we should be looking at what it is wrong with the system in order to make the court system more accessible. And in that regard, these changes in this Act make some good changes. One in particular which I think will cause an increase in the speed of decisions, perhaps make them a bit briefer than they sometimes have been. Decisions over the years have become longer and longer and longer, so that some of them read like academic treaties rather than a fair summary of the facts and application of the most central legal principles in order to reach a conclusion. Instead, we have ever longer judgments which take ever longer to prepare, which lead to ever more complex forms of process during the trial, and therefore cause both cost and delay and frustration to all those involved. Now, one of the ways in which this is being pushed against is this requirement on district courts to have information regarding reserve judgments. And the Chief District Court judge must now, once this legislation is passed, assuming it is, in consultation with the Chief Justice, publish information in relation to the process by which parties to proceedings before the court can obtain information about the status of any reserve judgment. It's a good change, because litigants who are facing undue delay ought to be able to raise their concerns and put a bit of pressure upon the decision maker to make a decision. But, Mr Speaker, I'm left with the sense that although these changes are good, and I agree with the standardisation of rules in the superior courts, and I agree with a lot of the other changes here, I'm still not convinced that we have tackled the nub of the problem, which is the efficiency of especially civil court processes, which remain beyond the pale for most people to settle their disputes through. Let's take the example of the Christchurch earthquakes. We've got this unprecedented level of claim and risk for the insurers. We've got insurers who have a practice, and I know this from my own practice, and I'm sure the attorney will be able to say what his experience and practice in respect of this was too. Insurers in respect of legal issues that are contested face a class action risk, and that if a decision has precedent value that goes against them, then they might have 100 cases over time that would have financial consequences for them as a consequence of that legal decision. Because of the enormity of the Christchurch earthquake event, some of those test cases, some of those legal principles that are contested would have effects on thousands of other claims that are on their books. The response of the insurance company faced with that possible, what I will call class action risk, I don't mean litigants joining together in a class action, but a lot of claims of the same class would line up behind those test cases. They are very reluctant to get a court decision that is adverse to their interest because of the class action risk that follows. The best way through that conundrum in the response to the Canterbury earthquakes, in my opinion, has been for some of those court cases to be brought through and have legal determinations as to what the legal principle is. Whether that goes for or against the insurer or for or against the insured, we would have more legal certainty for those advising insured, the people who've suffered losses, who are having claims that are being declined or that they can't settle. We would have desirable legal certainty which would enable the parties to that litigation to have their claims resolved, but would set a precedent for the thousands of others that follow. Now, because the cost of processes is so high, because the insurance companies know that they can elongate these processes, and because they face class action risk, there are legal impediments put in front of those trying to resolve those disputes. And when they get close to court, I bet so many of those cases are settling on terms that are confidential, that do not result in a legal precedent that would be useful to resolve all of the other thousands of insurance disputes that there are in Christchurch. And my problem with this legislation is I don't think it fixes that problem. And the two ways that that problem could have been fixed are, one, I believe that the Crown should have, in the public interest, be selecting 100, 200 cases that the Crown funded, not the insured, the Crown funded, because of the public interest and legal certainty in respect of the hundreds of thousands of claims that we have in Christchurch. The Crown should have funded some test cases which they could have established through a panel of wise advisors as to what were the legal principles and the legal disputes that needed to be resolved. So the Crown should have funded them in the case of Christchurch, but in the absence of the Crown funding them, those legal processes should be affordable, and they're not in New Zealand. And this legislation doesn't fix that. I'm a lawyer. I know the propensity of lawyers is to strive forever towards perfection. The striving towards perfection in respect of civil processes has gone so far that it has become the enemy of the good, and courts are not meeting their function, which is to provide an accessible means for the resolution of disputes. In closing, Mr. Speaker, this is good legislation. It does make progress in that regard, but the fundamental problems, I think, are not going to be resolved until we have what judges, or some judges and some lawyers, would see as pretty draconian rules, particularly in the district court, where so many proportion of cases have to be set down for hearing within, 60 days of filing of a statement of defence, where there are limits on the numbers of interlocutory proceedings, where judges take control of their courts, where there are quotas on the number of judgments that have to be delivered orally, where there are restrictions on the number of trials that are allowed to extend beyond a certain time period, so that we drive responsibility on the part of lawyers, on the part of judges, to control their own courts and provide access to justice.
I